Okay, I think we'll get started here. I probably don't need this microphone, but I'm going to use it anyway. For those of you who are students in my class, stop talking now. Just joking. I'm just joking. Today, it is my pleasure to introduce Kern Alexander, Professor of International Banking, Corporate and Financial Law at the University of Zurich, where he also serves as Director of the Competence Center for Sustainability in Law, Finance, Science, and the Humanities. Professor Alexander is also a fellow at Queen's College, University of Cambridge, and senior research fellow in banking and financial services law and regulation at the University of London's Institute of Advanced Legal Studies. He received his BA from Cornell University in history and government, a master's in modern European history from Oxford, an MPhil in international relations and LLB from University of Cambridge, Queen's College, and his PhD in law from the University of London School of Advanced Study. He has been a visiting professor at many universities around the world, including Harvard, the Max Planck Institute in Luxembourg, the Renmin University Law Faculty in Beijing, and the University of Utah S.J. Quinney College of Law. Professor Alexander is the author of numerous books and articles, including leading works on financial regulation, including Principles of Banking Regulation, published by Cambridge University Press, and Global Governance of Financial Systems, published by Oxford University Press. He has written recently on international banking regulation and climate change, central banking and inequality, and investor sustainability preferences, among other subjects. He has received a number of important grants to study investment regulation and has served as an advisor to the OECD, the European Court of Auditors, and the UK Serious Fraud Office. Today, Professor Alexander is going to deliver the Archibald McDougall Lecture on International Law. His lecture is titled International Law and Banking Regulation. Please join me in welcoming Professor Kern Alexander.
Thank you very much indeed, Professor Totolo, for that kind and warm introduction. Also, thank you, Dean Brewer, for your leadership here at the law faculty and hosting me this week and this month. It's a pleasure for me to be here and to give this lecture today. It's named, of course, after the donor, Archibald McDougall. And he was a British trained lawyer. He studied law at Oxford University in the 1920s and had a long and distinguished career as a diplomat, an international lawyer, and later he moved to West Virginia, as I understand, and had ties with West Virginia and the community here. So for me, that's a rich heritage, something I feel very honored to be here. I studied at Oxford as well and Cambridge, and so I understand sort of the perspective that someone may have had coming to the U.S. in those days, and so for me, it's a great pleasure and an honor to be here to give this lecture. Also, another fact that makes me very supportive and adds to some of the context of the lecture is that one of the previous McDougall lecturers was Professor Christopher Greenwood, who was professor at Cambridge University in the 1980s and 90s, and he was my supervisor and academic advisor when I studied law at Cambridge. And so I noticed that he was one of the previous McDougall visiting professors. So I hope that I can at least stand in the shadow of Professor Greenwood. He, of course, is a very prominent British barrister and professor, and he was also the UK judge on the International Court of Justice. And he's today the master of Magdalen College, one of the colleges at Cambridge University. So for me, I feel that this is an important tradition, and I'm very happy that although I'm American by birth, I had my legal education in the UK, and so I might be able to offer some cross-Atlantic perspective on some of the issues that I will be discussing today. What I'm talking about is international law and banking regulation. And when we discuss international law, we don't normally think about banking regulation. It's not really one of the high-profile topics that you would see in a public international law textbook, for example. However, we have seen in the last, say, 30 years or so, what many scholars and lawyers, such as Professor Greenwood, have called the fragmentation of international law. We see that international law has moved away from its traditional focus on interstate relations and the law of state responsibility and diplomatic protection, and we see it moving more broadly to include other areas of international life, international economic law, international intellectual property law, international criminal law, international human rights law. And these are all areas where there's been sort of a proliferation of norms and principles that have arisen in these different areas of the practice of international law, not to mention international trade law in the WTO. And so when one talks about international law, it has actually become a very broad field. And that, I would say, is a good thing, because the world is a complex place, and we need to have the rule of law governing relations between states and companies and individuals, and there need to be certain fundamental principles that are recognized in international law that can be transposed into local domestic legal frameworks. However, it poses a lot of challenges. Challenges in understanding what certain principles mean in different areas of international law. And sometimes there's the overlap of legal ideas from one area of international law to another. And so what I wanted to talk about today was to observe what has occurred in the area of international financial regulation. Over the last 30 years, we have seen the emergence of common principles of law and regulation in the practice of states. However, the common practices of states is not, it does not recognize international law as being applicable. And so scholars have called this international soft law. So where you have international norms and principles and standards that are there, they have kind of a normative effect on what you do, but they don't, but they don't have legal application. They do not invoke legal obligation. They do not invoke any certain specific legal rights. And that's been the case with international financial regulation. And we've had what I call soft law and international banking regulation. I'll talk about a bit to show this as an example of how what I would call international law has changed in the last 30 years, particularly in the area of banking and financial services. And the growth of law in this area, however, I would say has been accompanied by concerns about accountability and legitimacy, because the formation of these international norms are often done in an opaque environment, one where a few countries are involved and they exclude many other countries who are then later submitted to the standards and the norms and the principles that are adopted by these selected groups of countries. And that raises accountability and legitimacy concerns that I'll point out today. However, there has been recent improvement in that, where we've had more accountability safeguards built into the international standard setting process, which I'll talk on at the very beginning. But at a very basic level, those of you who've studied international law will be familiar with the basic sources of international law. The first source that's probably the most common is customary international law, a common or uniform practice of states, where states pursue a certain rule or admit an obligation because they feel they have a legal obligation to do so. This is called opinio juris, a belief that the practice they're engaged in is legally required. The other source of international law is treaties, either bilateral or multilateral. They're written agreements between states. They create binding obligations that are negotiated in advance, normally multilateral treaties at multilateral conferences, consisting of many different countries negotiating and creating rights and obligations with respect to certain fields of endeavor. And then, but the area I'm going to talk about today is the less discussed source of public international law. It's general principles of law, found at Article 38(1)(c). And general principles of law derive from what are known as principles common to the world's major legal systems. And at the time this was drafted in the Statute of the International Court of Justice in the first half of the 20th century, general principles of law were basically general principles that arose from civil law jurisdictions in Europe and common law jurisdictions, because those countries dominated the globe at the time. They had colonies, and their legal systems also had accepted European law in their common everyday practices. And so this area of law, though, has not been given much attention in terms of interpreting sources of binding international law. And I'm going to submit today that the area of international banking regulation that's been so far classified as international soft law, that this actually constitutes a source of general principles of law. What we have now with international banking regulation is a comprehensive system of standards, principles, norms, guidelines that have been adopted by states around the world, multiple states. And this has changed the nature of global markets, and it has created sort of a uniform framework of law and regulation to govern cross-border trade in financial services. The final source, I'm not discussing subsidiary means such as the writings of scholars and judges and the courts and tribunals, but I'm focusing on the general principles of law. And so the phrase actually is general principles of law recognized by civilized nations. And now the purpose, they've traditionally have been given the purpose as a gap filler. When treaties or customary international law did not apply to an issue, general principles could be resorted to interpret what a legal obligation or a legal rule or a remedy might be. And it often resorted to general principles of domestic legal systems to do that. The typical content of general principles, as I said, derive from domestic legal systems of the world's so-called leading jurisdictions. Examples include good faith, estoppel, pacta sunt servanda, prohibition of abuse of rights, and proportionality, amongst many other principles. And they should be, and so general principles and these principles of private law or even public administrative law at the national level should be distinguished from treaties and customary international law. They are a different source of internationally, legally binding behavior, I would submit. In order to identify the general principles, it involves the comparative method of law. Comparative lawyers would be familiar with this. Principles are identified by examining commonalities among domestic legal systems. It requires broad acceptance across different legal families, such as civil and common law. Also, general principles are identified by international tribunals, the International Court of Justice. As I mentioned, good faith, res judicata, the principles of equity are often referred to, proportionality in the use of force or in maritime delimitation. And recently, general principles of law have come in for a very close scrutiny by the International Law Commission. And so the International Law Commission has engaged in work between 2019 and 2023 in which they've published several papers, working documents to clarify the methodology for lawyers to understand how do we derive general principles of law from domestic law, and how can they become legally binding principles. What are the principles inherent to the international legal order that can be called general principles of law? And the overall objective is that general principles ensure coherence, consistency, and systemic integration within international law. So there's a lot of work being done by the International Law Commission to tell us what general principles mean. Okay, so now what I'm going to do now is shift over to international soft law. With that as our background, I want to first point out that many distinguished lawyers have looked at international soft law and have argued that public international law does not apply. And Joseph Gold was one of the most famous ones. He was the former general counsel of the International Monetary Fund. He was a British barrister, and he was very prominent as a writer, a commentator, and also as a legal practitioner. And he basically defined international financial soft law, which applied, he said, to the International Monetary Fund and other areas of international financial regulation. He defined it as an essential ingredient of soft law is an expectation that states accepting these instruments will take their content seriously and will give them some measure of respect. Certain other elements are postulated. First, there's a common intent among states that is implicit in the soft law. as formulated. And it is this common intent, when elucidated, that is to be respected. Second, the legitimacy of the soft law, and the bold highlight is my emphasis. Second, the legitimacy of the soft law as promulgated is not challenged. Third, soft law is not deprived of its quality as law because failure to observe it is not in itself a breach of obligation. And finally, soft law involves conduct that respects soft law cannot be deemed invalid. So in a way, he's made a statement, soft law is not just something that you can do or not do. That soft law does have this kind of normative effect, and that it arrives in the international context because of a common intent among states. States agree to accept, even though they don't feel they have a legal obligation to accept, but they pursue or implement or accept a certain principle, standard, or a rule, a norm. And by doing so, it gives it a certain legitimacy by doing that. And the fact that it's not enforceable in a legal court does not deprive it of its quality as law. So I think Gould's idea of soft law was one that influenced international banking lawyers, and I would say international bank regulatory lawyers. So this area of study took off in the 1970s and 80s. Banks began to be global, operating in multiple jurisdictions. They were confronted with regulations that were different in different countries, and there was a need to promote more common approaches to financial regulation in order to create a level playing field for banks to move and operate on a transnational basis. And so the soft law framework became like a minimum standard that countries began to adhere to in their local national law and regulation. The Basel Committee on Banking Supervision is probably the most important body for setting international soft law bank regulation standards. It has a mandate from the Bank for International Settlements, which is in Basel, Switzerland. It has a mandate. The BIS is an international organization with 84 member states. And the Basel Committee on Banking Supervision is a so-called soft law body. It doesn't really have a formal institutional structure, but yet it's a grouping of state representatives who come together periodically in Basel, and they meet and they negotiate and deal with issues that are common to the banking sector internationally. And they propose standards and rules that countries are expected to then go back and implement in their own practice. And so this is a quote from their website, actually, where it says standards. The Basel Committee for Banking Supervision, BCBS, sets standards for the prudential regulation of banks. The BCBS expects full implementation of its standards by BCBS members and their internationally active banks. However, BCBS standards constitute minimum requirements, and BCBS members may decide to go beyond them, to have stricter standards, in other words, if they want to do that. Further, the standards state the committee expects standards to be incorporated into local legal frameworks through each jurisdiction's rulemaking processes within a predefined time frame. If deviation from a literal transposition into local legal frameworks is unavoidable, members should seek the greatest possible equivalence of standards and their outcome. So this is just more than just something that you can do or not do. This is something where there's an expectation that states will take these principles, these standards, and go back and implement them into their own national laws. Now, probably the most comprehensive set of principles adopted by the Basel Committee are the so-called Basel Core Principles of Banking Supervision. There are 27 high-level principles that define the minimum requirements and principles of supervisory practice for bank regulators. These principles were revised in 2024. The revision was triggered by the post-global financial crisis of 2008 that some of you might recall, where the whole global banking system went into meltdown and was bailed out by countries having to bail out banks because of weak regulation and weak corporate governance. But also the principles were revised in response to COVID-19 disruptions, which led to economies falling into recession, led to a lot of financial stability problems in countries. and also to the mini banking crisis that occurred in 2023, in which SVB Bank and Credit Suisse had to be, were basically, SVB had to be put into receivership by the FDIC, and Credit Suisse was about to collapse and was taken over in a government-forced takeover by UBS. And so these core principles are not panaceas. The standards that are implemented by countries have not prevented global financial crises from happening. They're still happening. The principles have a lot to be said regarding their flexibility, but their implementation and application has left a lot of problems and challenges for local supervisory authorities. And that is where a review of these principles has come up now. The new principles focus on stronger corporate governance of banks. It also has an explicit focus on operational resilience, a focus on systemic integration of climate risk across the framework, and the proportionality principle. The principle of proportionality is highlighted as being crucial, essential, that it applies across the board in the application of bank supervisory practices. So essentially, these Basel core principles and other Basel standards, also an important standard is the Basel Capital Accord, which provides minimum levels of capital that banks should hold when they're conducting their business. They are not treaties. They're not part of state practice, uniform practice of states, opinio juris. They are legally non-binding. Countries actually don't have to do them. However, what is, as an empirical fact, over 100 countries worldwide have implemented them into their domestic regulation. The Basel rules have become effective. They become legally effective when they're implemented by countries into national law and local frameworks. The United States has implemented Basel a little bit differently than other countries. The U.S. applies the Basel Capital Accord only to internationally active banks, but to other areas of banking regulation, such as the Basel core principles that I just mentioned, they apply them to all banks, big banks, small banks, community banks. And so the implication is that global banking regulation is harmonized in principle, but there are divergences in practice due to national discretion. So we have this international framework. Countries have got flexibility in how they implement them. But one of the criticisms of the whole soft law approach has been that the Basel Committee, but not just the Basel Committee, but many international standard-setting bodies, their membership is normally consisting of 12 or 15 of the world's richest developed countries. The EU, US, Japan, Australia, a few big emerging market economies like Brazil, South Africa, China, but not many other countries are on these standard-setting bodies. And so these principles are basically adopted by a small grouping of countries, and they are applicable and expected to be implemented by countries all over the world. And that has raised concerns about accountability and the legitimacy of the principles. And so, for instance, there's no technical international legal obligation to implement the Basel Capital Accord, but for most countries, the incentives and the sanctions that are attached to not doing it are stronger than generally recognized. And this is a quote from the World Bank. In 2014, the World Bank wrote that the international community is likely to expect all banks to adopt and implement the Basel Committee recommendations. So you have this big institutional pressure by the World Bank, by the International Monetary Fund. The International Monetary Fund has so-called financial sector assessment programs, FSAPs, and they use these to perform surveillance on all member countries of the IMF. And so part of this FSAP surveillance exercise requires countries to report to the IMF whether they're complying with the Basel core principles or the bank capital requirements and other requirements like the Financial Action Task Force on International Anti-Money Laundering Standards, the International Organization of Securities Commissions, IOSCO adopts securities regulation standards. All of these soft law bodies are essentially dominated by the world's few industrial leading countries. Also, market discipline imposes pressure on countries to adopt these standards. it's been shown empirically that sovereign debt issued by developing countries is higher if they are in a country that does not adopt the Basel framework, if they're not implementing Basel into their local regulatory framework. Also, for many multinational banks, they lobby countries to adopt Basel-compliant regulatory frameworks because multinational banks want to have a one-stop shop. They want to have a level playing field on regulation. They don't want to go into countries where the standards are stricter or not conforming to what Basel wants to do. And also, there's a general reputation risk that a country runs if they are not seen to be Basel compliant. It can set off possibly a loss of confidence by investors. And you can have suddenly foreign investment can stop or be limited for countries that are not viewed to be Basel compliant. So these are all things that have been shown empirically. Again, the IMF, as I said, and the World Bank have had these sector assessment programs, financial sector assessment programs, in which countries undergo the Basel Core Principle assessment. They receive ratings such as compliant, largely compliant, or non-compliant, or largely non-compliant. And it's a tick the box, and it's shown to it's put on the website of the country on the IMF. Reports reveal common gaps, often in the supervisory and regulatory frameworks that these countries have. They show what resources the countries have for carrying out regulatory tasks. And not only does the IMF do these assessment programs, the Basel Committee has their own regulatory consistency program. It monitors the timely transposition of Basel Accord standards into domestic regulations based on information provided by each member jurisdiction. The Basel Committee assesses whether the domestic rules of that country are compliant with the Basel core principles and with the Basel Capital Accord. So you have this pressure, the international standard setting bodies performing surveillance along with the IMF about what countries are doing in their regulatory practices. And it has led to a number of publications empirically to show what countries are adopting the Basel core principles and bank capital requirements and which ones are not. And it's shown that as of today, 70% of jurisdictions worldwide had finalized rules that were in the final stages of implementation. There are variations that persist between countries. For instance, the European Union implements most standards because it's the law of the EU to do so, but some countries have delayed implementation of standards for various local reasons. And the US recently has announced that they're going to move away from some of the international standards that coming out of the Basel Committee under the new administration. But essentially, as a general principle of law, the core principles of banking supervision have been retained across all jurisdictions. And they remain legally relevant in national domestic legal frameworks. And this is to show that you've got basically complementary approaches for performing surveillance, for determining which countries are adopting these standards and which countries are not. This is largely dominated by the executive board of the IMF, the Basel Committee on Banking Supervision, the Financial Stability Board, and together they publish both qualitative and quantitative information on what countries are implementing these standards and which countries are not. And what is shown is that most countries worldwide are, at least in law, they're implementing the standards. Now, law and practice might be a different thing in these jurisdictions, but at least in legal frameworks among African developing countries, they're almost fully compliant with the Basel framework. And based on this, I would submit that if we think of general principles of law and soft law in the area of international financial regulation, we might think of it like this, have a framework in which at the bottom we've got international soft law, the Basel Accord, the core principles of banking supervision, and many other international standards. And then the soft law principles produce uniform principles of legally binding law adopted across multiple states. And from this, we can see emerge binding general principles of regulatory law in terms of Article 38(1)(c), that we could call these principles binding, being a binding source. and then and they would be legally relevant as binding international law. And so now I would say that this looks like a very coherent framework that we might say works, right? But as I mentioned earlier, there's been a lot of criticisms of the Basel framework, that those who are adopting these standards and devising these regulatory rules, or it's a small grouping of countries that are doing it, and they are applying them to countries all over the world. And they do so by saying, well, these are soft law. You don't have to do it. But we see that there are institutional pressures for countries to implement these standards into their local jurisdictions. And therefore, they are being pressured to do so. And empirically, most countries are adopting these principles and rules. So it raises questions of accountability and legitimacy of the standard setting process that I would submit. And about 20 years ago, I co-authored a book called Global Governance of Financial Systems, in which we argued that international financial soft law has a normative impact on national and domestic regulation of states. It aims to enhance prudential and conduct of business standards in a flexible, non-legalistic manner. Our study, however, questioned the effectiveness and accountability and legitimacy of these international standards because, in many cases, most states still suffered from banking crises. They continue to suffer from so-called financial fragility, volatility in the price of financial services, and volatility in interest rates. And the international standards have essentially failed to address many of the institutional and structural aspects of developing and emerging market economies. So that's one of the takeaways I'd like to bring from this, is that although we may have these new binding general principles of administrative regulatory law that the IMF is very proud of and the Basel Committee is proud of, we see that their implementation has had differential effect across many countries, and in many countries not such a good economic effect. Now, what are some of the future challenges? And I'll finish up on the future challenges that the Basel Committee and these standard setting bodies have. And I would say the future challenges are, you might sum them up by saying there are climate finance risk, the risk of digital currencies and cryptocurrencies, and the risks that so-called shadow banks or non-bank financial institutions pose to financial stability. Non-bank financial institutions are not regulated for capital. They're not regulated for prudential safeguards like regulated banks are. And then finally, the big challenge is U.S. involvement. The U.S. has exhibited that it might pull away from the Basel framework, and whether that, what are the implications of that? And so just to run through these challenges, we have climate change presents financial risk. It's been shown by economists that it's not just something that we want to achieve, to have a cleaner environment. It also, climate change is causing financial instability in many countries in the world. It's creating differential impacts in financial stability risk that need to be assessed. And so we have, so regulators need to be addressing this from a risk identification point of view, a governance point of view, and also by using stress testing that incorporate climate finance risk into their stress testing models. And there needs to also to be disclosure of climate finance risk. So that's one area that's not yet been fully embraced by the Basel Committee. This is under debate, and I highlight where these could fit into the current core principles right now, where climate change risk could fit in. The other challenge is supervisory challenges of many supervisors. They have data limitations, model uncertainty. The time horizon mismatch of climate risk is long term. How do we begin to address that over the shorter term? And that the impact of climate finance risk is on banks, and it means that bank corporate governance needs to change. Bank corporate governance, the role of the board of directors, needs to be a bit more longer term in thinking about how they can manage these financial risks that are going to affect the company and the bank in the future. The other big challenge has to do with cryptocurrencies, digitalization. And this affects what is called operational resilience of banks. The fact that you can have digital, the digitalization of financial services creates a lot of benefits, economies of scale, but it also creates a number of risks of IT breakdown, of cyber crime, fraud, and so regulators need to be embraced and looking at the issues of operational resilience. The issue of outsourcing data to clouds is also a potential risk regarding data protection. And so these are all examples of where regulators need to be focused in the future based on the core principles. I mentioned earlier shadow banks, the so-called non-bank financial institutions. This concern is that shadow banks are not regulated financial institutions, but they are growing big and systemic themselves, like Apollo Management is a classic. It's a private equity firm, but it's not regulated for prudential regulation. In the US, it's one of the biggest financial institutions. And so regulators need to begin to assess the links of big private equity firms, big private credit investment firms, their links with banks to see if systemic risk might transmit to the regulated sector. And so the supervisory focus needs to be broader, more what I would call macro-prudential, more looking at the whole financial system, not looking at individual institutions within the financial system. And this is going to require enhanced supervisory capabilities, using group-wide data across the whole group of companies, expanded oversight over technology-driven business models and fintech partnerships. Okay, now the last challenge is the challenge of the US. Internationally, the US has been a key player in these international standard-setting bodies. And the Basel, it was one of the founding members of the Basel Committee. It's been right there at the forefront of the development of the core principles of banking supervision, applied across the board. And sometimes, you know, the influence of the US hasn't been so economically productive. It leads to some light touch regulation, but generally the US is a big market. They need to be at the table. And they've always been engaged. However, the new Fed governor who was appointed last May, Michelle Bowman, gave a speech on June 6th, in which entitled Taking a Fresh Look at Supervision and Regulation. And in that speech, she says, we need to go back and revisit these principles from the start and have a more holistic review of bank capital regulation. We need to adjust the enhanced higher capital requirement for big banks. Big banks have a so-called supplementary leverage ratio. They have to hold more capital than a regular bank. And so she wants to adjust that, even to eliminate it in the US. She also doesn't want stress testing to be so rigorous, or she wants it to be transparent. So stress testing is normally done secretively between the regulator, like the Federal Reserve, and the bank in question. She wants to have more transparency and disclosure of stress tests, how the models are designed. You know, there are arguments, pros and cons on this. And also she wants to reassess bank capital buffers and surcharges, and to tailor regulation to make it much more lighter touch for smaller and community banks. Now, all of these could be very sensible proposals, but it's important that the US engage fully, I think, with the international bodies on this, and that any change that happens, that it be an international agreement on which it is based, and not US unilateralism, because it might lead to divergences in regulatory practices that might undermine financial stability. So those are some concerns. If any of you are interested further in this, I gave testimony to the British House of Lords Financial Services Committee on July 2nd, talking about the risk of climate finance risk, shadow banks, and differences between US and EU regulation. So if any of you are working on this, some people in my class might be interested in that. But to sum up, I think the main point would be is that we used to treat international soft law as something that was optional. It wasn't really something to be worried about as a policy concern. But we've seen that international soft law has taken on a momentum all of its own, and it's become implemented in countries around the world, and it's become essentially a general principle of law in the area of banking supervision and regulation. And therefore, it's legally relevant. And therefore, how we make that soft law, how we make those principles, is much more of a concern of policymakers. It's just not something that we can take it or leave it. It's something that matters. It's implemented globally. And there needs to be more accountability and more legitimacy built in to the standard setting and to the decision making that goes about in developing these soft law standards. So thank you very much for listening. I'm happy to take any questions. Yes. Okay, that's a very good question. The question is about soft law and what type of sanctions. How do we ensure that the soft law standards are adhered to or fulfilled if there are no effective sanctions that can be applied? Well, the Basel Committee is made up, it consists of representatives of the G20 countries, who are the richest countries in the world and the largest emerging market economies in the world. These countries come together, they agree the standards, and then they make a political commitment, you might call it, to go back and implement it into their own national law and regulation. If one of these countries doesn't do what they promised to do, they are probably not going to get penalized from it. But there is some data to show that some countries, some emerging market economies, actually experience higher yields, higher interest rates they have to pay on their government debt if they're not shown to be compliant with these soft law standards. So there's a market sanction, a market-based sanction that often is applied to many countries that are not demonstrating to the market that they're compliant with the Basel framework. Now, but there's not much of an official sanction. You don't invoke state responsibility or go to tribunal or anything like that. And that's where the second type of source of a so-called sanction comes in, and it's if all countries are reviewed by the IMF and the World Bank through their Article 4 financial sector assessment programs. And the World Bank and IMF publish reports on every member country on whether or not they're complying with all the international financial standards, not sanctions, international financial standards like banking, insurance, securities, financial crime, terrorist financing. And if countries are not shown to be that complying, they're named and shamed by the IMF and World Bank. And now for the US or Germany or Japan, being named and shamed by the IMF is really they're not going to lose sleep over that, right? It's not going to bother them. But for most other countries in the world, if you're named and shamed by the IMF, it can create reputation problems in the market. And it can in turn lead to foreign investors being less willing to do business there. Multinational banks often pressure local governments to be compliant with the international standards because they want to have a level playing field across which to do business. And so the effect of the IMF, World Bank naming and shaming, and also the Basel Committee, I pointed out on an earlier slide that the Basel Committee has their own consistency assessment that they do. And for many countries that don't comply or who are criticized, it does affect their market position in the market and can affect their cost of capital. But you're right, there's no formal legal measure that can cause you to be brought before a tribunal. Now, interestingly, though, I have been an expert on bilateral investment treaty cases involving foreign investors who invest in host countries. And in these cases, a defense, the foreign investors often allege that the host country has overregulated, has regulated so strictly that it's undermined the value of our investment. And therefore, it's violated the protection of investment provisions of a bilateral investment treaty. The regulators often are allowed to have a defense if they can show that their regulatory practices, although strict, are complying with the Basel framework. So in bilateral litigation with foreign investors, and this is not legal precedent. All countries don't do, but in many tribunals, the Stockholm Chamber of Commerce, the Paris Chamber of Commerce, there are a number of arbitration tribunal rulings in which the country's defense is based on we are Basel compliant. And so what they do is they bring an expert academic in who, like I go in, I did a case where I worked with the government of Poland, and I had to do an assessment of whether they were Basel compliant. And that was part of their defense against a claim from a foreign investor that they had not, that the regulation was too strict, had undermined the value of their foreign investment. So that has a kind of an indirect legal effect. So these standards are not just purely soft law that the IMF sort of pressures countries to do. They're beginning to have increasingly legally cognizant, you might say, in these dispute tribunals. Yes. Well, the question has to do with the U.S. and that the U.S. Or Germany, other large countries that don't really depend on the IMF for financial support. They're a big country on their own. What would prevent them from continuing to abide by the Basel principles, right? Is that essentially? Right, right. Yeah, well, nothing prevents them from not complying. So they can not comply. But it would reverse 50 years of international cooperation and coordination. And I think that would be a rather risky move because the Basel Committee was originally founded in 1975, not really because of adopting regulatory standards. It was set up for a very practical purpose. A small regional German bank had become insolvent, but it had a lot of liabilities against big systemically important US banks and banks in the UK. And if that bank was allowed to become insolvent, the big US banks were going to have huge losses and maybe even have to be restructured by US regulatory authorities. And so they set up a hotline between central bank governors in 1975, and they set up a principle, what they call home host country control, where the home country of the bank takes the lead in coordinating with all the host country jurisdictions where the bank operates. And so if there's a problem with that bank, the central bank governor knows who to call in Germany or in Japan in order to stabilize the crisis. Now that was of mutual benefit that the US was part of that, because if the Germans had not cooperated, then they would have had a systemic crisis in the US had they not been able to resolve this bank called the Herstatt Bank. It was the Herstatt Bank crisis of 1975. So I would say the US will stay in, Germany will stay in, because there are benefits to having cross-border coordination. The US could say, we're going to withdraw, not do these standards, we're really a big player, but you might have another situation like Herstatt in 1975, where you need to pick up the phone and call the ECB president and say, can we work together to stabilize a cross-border failure? And if they say, well, you're not in our club, we're not working with you, we're going to do what's good for us, but not for you, then the U.S. can lose economically on that. So I think that's going to be why the U.S. stays in. I think there's political rhetoric saying we're going to go it alone and be unilateral, but there are too many benefits for the U.S. to stay part of these international bodies. And from that, we'll see these principles emerge, these so-called general principles of law that I talk about. Yes? Yeah. Yeah. Yeah, that's a very good question. Have we seen this kind of conceptual framework that I've submitted today about soft law becoming uniform? It's adopted by countries across the board, and then it generates a legally binding effect. It becomes a general principle of law. Have we seen this in other areas of in other economic regulation, you might say? Not that I know of. In the financial regulation area, it's a pretty broad one: insurance, securities, financial crime, and bank capital. I focus more on bank capital and Basel core principles today, but it's kind of a wide area of financial regulation that where it has happened. But I don't, I don't know of anyone else who's made this argument that it's a binding general principle of law, because it's politically so unpopular, because the Basel Committee will tell you, oh no, although we say everyone's got to do it and we have expectations, this is not legally binding, you don't have to do it. Because that would kind of politically kill the exercise, the fact that everyone thought, my gosh, we're really engaged in creating binding international law. And so I don't think this is a popular position to take, and it requires really an academic like me, who's followed this industry now for 25 years, to sort of say, look, this is what's really happening. You're making international law through the back door, essentially, without the accountability safeguards that you should have in making such law. Because if you were to say it was binding, you'd have to have a big convention, you'd have to have all this bargaining back and forth. It would take, logistically, it would be very difficult. So I don't think, I don't know of it being done in any other industry, but I wouldn't be surprised that this is not, that you could probably observe it in other areas of global economic activity. Yes?
Go ahead.
Yeah. Yeah. Yeah, no, it certainly could be. And I was just talking with Professor Totolo before the lecture, and we talked about the principle of good faith in contract law and how that's in the UCC, right? And so you might say that at least it's a general principle of law, of contract law in the US. But in England, they don't have the principle of good faith unless you put it in the contract. But still, the UCC could be a source of common general practices, principles that then elevate, that could rise if they're adopted by other states outside the U.S. They could arise to the level of a binding international legal requirement.
I actually had a question myself.
Yeah, oh, okay, yeah.
Sorry, I don't mean to throw it out there. It may be something I may need to ask you later on because it's more like nuanced. But in regard to the Basel Committee and with local, I guess, well, with U.S. laws and organizations that we have to regulate things, my mind immediately goes to OFAC and thinking about how this would regulate countries that need to prevent other countries that are on the OFAC list. How does this correlate, I guess, with the things that are on everyone's mind with cryptocurrency and fintechs that are able to operate without observing any of the regulations that are put in place by the U.S. government? My thought was on that. Is it the hope that the Basel Committee's soft laws will actually be adopted by many countries in order to mitigate the cryptocurrencies and bypassing OFAC?
That's a very good question about cryptocurrencies, and that is an area that the Basel Committee is focusing the core principles on now, but they haven't come up with standards for it. And there's a Basel Committee working group on cryptocurrencies that was opened in 2019, and it's on their website, and they have a discussion paper. But no standards have come out of this yet. And so that's an important point, and I think that's areas in the future. Those are challenges in the future: crypto, digital finance, climate finance. The Basel Committee wouldn't accept climate finance as a risk for a long time. In fact, I wrote a report that was mentioned earlier in 2014 saying climate change does pose financial risk for banks, and I had data to show this. And I wrote a report on this for the UN, and so I was asked to go to the Basel Committee to present it. And the Basel Committee said, we don't really deal with the environment here. And we're not an environmental body. And I said, well, no, my point is that the environment presents financial risk, and that's why it's relevant for banks. And they listened, and they actually, it wasn't just me, of course, there were a lot of sustainability lobbyists that were promoting this argument that the banking regulation cannot ignore climate finance risk. They're out there. They're becoming more pronounced, and they're affecting company and bank balance sheets more, and the risks need to be assessed. And the regulators need to be asking questions of banks, how are you assessing these risks? And that was essentially what I was saying. And then the Basel Committee had nothing on this. But now they have a working group on this. I like to say that I was in at the bottom. It wasn't just me. There was like a whole group of, there were a group of us who went there, and I gave my talk, and this was in 2015. It was a really exciting time. And it was right when the Paris Climate Change Treaty was signed. And it wasn't meant to say, look, it was simply to say this is relevant for the banking business because there are financial risk involved. We're not trying to say the banks should try to lead the way to having a cleaner environment. I mean, but they need to take into account these risks as they occur. Now the other thing you mentioned was OFAC, sanctions. Sanctions are dealt with internationally by the Financial Action Task Force, FATF, they're called. They're based in Paris at the OECD. And FATF has got the so-called 49 recommendations. They're called recommendations, right? But if you don't do it, you get named and shamed. They have a blacklist. Switzerland, unfortunately, was on the blacklist for a while when they had very strict bank secrecy because they said it was facilitating money laundering and tax evasion. And so Switzerland came clean, and to their credit, about 7-8 years ago. And so now they're off the FATF blacklist. But other countries get put on. Often emerging market, developing countries, countries with more political influence don't often get put on this so-called blacklist or brown list, whatever you might call it. But it's an informal way of sort of naming and shaming countries that are not complying with these international standards. And so we see this in the area of anti-money laundering controls and sanctions. So you mentioned OFAC. So, yeah. Thank you. Yeah, thank you for the question.